Good evening. Welcome to Issues, and I'm your host, Richard Smith. Today we will be talking with Caljonah Smith, an attorney with one of the local firms here. We're going to be looking at wills. Is it necessary to have a will? What are some of the benefits of having a will? Now, Caljonah, welcome to Issues.
Thank you for having me.
My first question, what are the differences among these three terms? Living will, enduring power of attorney, and just plain will. Let's start off with a living will or health care directive. What is that one all about?
A living will, also known as a health care directive, is a legal document that was handed to your doctor as well as to your next of kin, and letting them know that if you're in a situation where there's no chance of recovery, where you have a situation where you're terminally ill, and you don't want to be put on any type of life support, that it says basically pull the plug document, and this is your wish, that you don't want to be on any type of artificial mechanism to keep you alive. So that's something that I would recommend people do if they strongly believe that they don't want to be on any type of life support. And it makes the decision for the family easier for them to make the decision if the time arises.
Okay. Now, the next term that we're going to be looking at here is enduring power of attorney.
Mm-hmm. So an enduring power of attorney is a legal document which comes into effect in a situation where you might have lost mental or physical capacity to handle your own affairs. So, for instance, you may have had a stroke and you need to have someone to assist with your finances or your physical affairs, your
financial affairs?
Financial affairs. Yes. Then you would have them step in and do all the things you would normally do had you had capacity. So situations in which it can come into effect, as I mentioned, if you've lost mental capacity, then a doctor would have to issue a certificate stating that, in their opinion, you do not have capacity to handle your affairs.
Yeah, now, this enduring power of attorney, or just power of attorney, does it only come into play when someone has lost mental capacity to make decisions for him or herself?
That's one of the ways it can come into effect. Or say, for instance, you still have your faculties in order, but you just need someone to assist with paying bills for you, doing errands on your behalf. Then you can have one that comes into effect immediately, so it doesn't come into effect on the you losing capacity. Mm-hmm. So that's another way that an enduring power of attorney works.
So then the living will or health care directive, as compared to the power of attorney, the living will deals with not being hooked up to any mechanism to keep you alive or prolong life.
Right, correct.
The power of attorney, that one deals when you are incapacitated and cannot make decisions for yourself.
Right. Then
that one comes into play.
Yes.
And someone can go to their attorney and get both of these documents done up.
Yes, that's part of our advice to clients if they come in, and they might just come in to say they want to do a will, but we also would highlight these other types of legal documents that they can have prepared to deal with those situations.
Now, just the plain term will.
Mm-hmm.
Okay. What is that one all about?
Okay, so a will is basically a legal document that is speaking on what you want to happen with your estate on your death. So it doesn't come into effect until your death, which means up until that time that you've prepared it, you can make changes to it as you acquire assets, as you dispose of assets during your lifetime. So it's basically stating who you want to inherit from your estate.
Okay. Now, many times we hear people have written their will on a napkin or on the tablecloth. Are those things legal?
They are legal, but there are requirements that the Act specifies how, if someone is going to do their will themselves, specifications such as it has to be in your own handwriting, it has to be initialed on each page, and so forth. And then the downside of it is that you would need someone to verify your handwriting, that this is you and this is your last will and testament. So oftentimes we would or highly recommend that you get one prepared by someone who's qualified to give you the proper advice to make sure that there's nothing that you might have written on the napkin that might not be valid at the end of the day.
Let me give you a scenario, and you asked me if the will would be legal. Someone has gone to attorney, they've made a will, the will is locked in the vault of the attorney, and one day they're out at dinner, and they say, you know what, I want to change my will. And they just take a napkin that's there, change the will, I leave everything to Richard Smith, and then in their own handwriting, and somebody witnesses that. Can that person take that napkin and take it to his or her attorney, and would that replace the first will that they had?
Well, in that situation, if they brought the napkin in, I would say, now let's make sure that we get this done correctly, and take those instructions and do a new will with those new provisions.
Okay. Now, is a will only necessary if someone owns property, a home, a land, those type of things?
Not necessarily, because sometimes a person doesn't know that they've inherited from someone's estate and have an asset. So you don't have to necessarily wait until you have an asset to do a will, but you should consider it in the event that you might inherit something during your lifetime, but not have had a chance to prepare a will. So for instance, say someone has been in an accident and they pass, and there's a person who caused the accident and caused the death, then the state could possibly have a claim against that individual and have some, awarded to the estate. So in that sense, what would happen with, the receipt of that award for the accidental death? That can specify who would receive your estate.
Okay. Now, who can make a will? That may sound like a silly question, but are there age requirements?
Yeah, you have to be of legal age, which is 18 here in Bermuda. You have to have a sound disposing mind. So, for instance, knowing what assets you have, how you earn them, who you want to benefit from it, as well as the consequences of giving a particular asset to someone, that you fully understand that by disposing it to that person, that you are gifting it to them in your estate.
At what period in a person's life would you recommend that they make a will?
Definitely if you have assets, you should make a will. And also, like I mentioned earlier, you don't always have to wait till you have one. So if you have children, spouse, there's the times you should consider making a will. Some people feel that if they own assets jointly, that there's no need to make a will because it's automatically going to go to the survivor.
I was heading there with that is my next question. Go ahead.
So in that situation, although you may feel that if you predecease the person you own this asset jointly with, you should also consider, what if you are the survivor? In that situation, then you would own the asset solely in your name, and you need to consider who would benefit from it. So some people feel, okay, husband and wife, I don't need to make a will because everything's going to go to my spouse. But you need to also consider, what if your spouse predeceases you and you haven't made a will for, you just hadn't had the time to do it, or you might have lost capacity. And then you cannot make a will because you need to have mental capacity to do a will. So it's important to do it as early as possible, just to get those affairs in order. And you can always update it as you acquire assets or dispose of them during your lifetime.
So even husband and wives, they should make separate wills?
Yes.
Okay.
Yeah.
Now, in your experience, what are some issues that would cause a fight over wills?
Over a will?
Yeah.
Situations where, say for instance, a parent has left one house to 5 children. Sometimes the children may not all get along, or they have their own responsibilities. They have their own house and so forth. And it's difficult for everyone to contribute equally to something they've inherited. Some want to choose to sell the property, whereas others feel they should keep it, or that it should be sold for more than what has been listed for it to be sold for. So in those situations, there can be some friction with leaving one asset to multiple individuals.
Let's just continue with that, because in Bermuda that happens quite a bit. Can a will be written in such a way to avoid that type of problem?
Yeah, so for instance, if someone comes in and says to me that they want to leave their house to 3 children,
yes,
I would, suggest that they reconsider it, understanding that they want to be equal. They want, each child to receive equally, but then saying, sometimes a particular child has their own mortgage and expenses associated with the house, so maybe leaving the bank accounts or some shares that they have to to a particular child and the house to another, so that each would have an equal share in the entire estate.
Okay. Well, are you suggesting that if an individual has one house and more than one child, to leave it to that may not be the best solution?
It may not be the best, or a solution to that would be to say, to
sell
put provision to
sell
the house and to divide the proceeds.
I was joking.
and if one of the children feel that they want to retain the house, they can buy the other children out, the other siblings, I should say.
Very good. Now, is there ever a situation where a will can be revoked?
Yes. You can have the intention to revoke it, so you can destroy it. You can revoke it by creating a new will, or you can do a codicil to your original will. So in that sense, you're just making an amendment to your last will and testament. So for instance, you want to change your executors, or you want to add a beneficiary to your estate, you can make provisions in your codicil to revoke something that's in your will. Or you can marriage actually revokes a will if not made in contemplation of marriage.
Marriage revokes a will?
Right. So if you have a will and then you marry, the act says that the marriage would revoke your last will and testament.
So if someone has a will written as a single person, then they get married. Once they are married, the will that was written when they were single is now revoked?
Correct.
Wow. So they would have to write a new will.
Yes.
Many people may not be aware of that, so I'm very happy that you pointed out that once you get married, whatever wills that you had written before are now not in existence. In terms of witnessing, how many must a will be witnessed? All wills must be witnessed?
Yes.
Is it one or more than one individual?
It's 2 independent witnesses is what the Act states to have witnessed, for have a will witnessed. They must be independent simply because the Act says that if the witness is a beneficiary or a spouse of a beneficiary, that gift to that beneficiary will be void.
Okay. So if I go to the attorney and I bring my cousin with me, and I say, okay, I want my cousin to witness this will, but in it I've left my cousin $50. He cannot be a witness because he is inheritor of something in the will.
Yes.
Okay.
Yeah.
And I can see the reason. Well, what would be the reason not having someone who's named in the will as a witness to the will?
Because you don't want anyone to make a suggestion that the person who made the will was influenced by that individual to make a provision for them in their will. So to avoid any doubt, you want to make sure they're not a beneficiary.
We're talking with Caljonah Smith, an attorney with one of the local firms. We're going to take a break and we will be right back. let me give you a scenario. Mr. and Mrs. Jones, they're married. They have a will. They've been married for 15, 20 years. They get a divorce. Mr. Jones marries somebody else. The will that he made with the first Mrs., is that will now null and void because he has remarried?
No, actually the will is still valid, but what the act says is that the gift that is meant to go to the now ex-spouse will be considered void, so that it will go to the contingent beneficiary instead of the ex-spouse.
Okay, so the will is still valid, but whatever was supposed to go to the ex-spouse doesn't go to that
Correct.
ex-spouse?
It will go to whoever the contingent beneficiary of the gift to go to the ex-spouse.
But the remaining terms of the will still is
still be valid.
Wow,
yes.
Interesting. Okay, what are some terms that one would find in a will?
Okay, so in a will, you want to make sure that your name and any aliases are clearly stated so that you are properly identified. So, for instance, you may have people who go by their middle name, and everyone knows them by their middle name. So it's important that you list all of the aliases that you may go by.
Now, in Bermuda, people have a lot of nicknames. So you mean if they're going to write a will, they have to put those nicknames in the will also?
I mean, sometimes we do put them in if they're commonly known by that nickname.
Wow.
Yeah.
Okay. Go ahead. Some other terms?
Other terms you can include in your will is if you have any type of burial wishes. You may have a burial plot that you have set aside. You can specify the grave number that you have. You would also, very important, have your executors listed, as they will be the ones who would make an application to the Supreme Court of Bermuda to probate your estate if it's needed. Your executors have a huge role in your estate.
Those your attorney, isn't that your executors and attorney? That's not one and the same?
No, it wouldn't be one and the same. Your executors are the ones, like I mentioned, who administer the estate. You have attorneys who assist the executors with the gathering of the necessary information and assisting with the application to the court to probate the estate. There are stipulations where if you have minor beneficiaries in the estate, you need at least 2 individual executors or a corporate company to administer the estate. Also, it's very important that you consider substitute executors who would step in should your first name executor not be able to act. They may have predeceased you, or they may have just be unable to assist for whatever reasons they have. So you want to make sure that your executors are on board, that you have communicated to them, that you have appointed them as executors so that they are not surprised when they have been told that they've been named as executor. So you want someone that you can trust and who pretty much would be able to do the job right.
Okay, are there any other terms, guardian? Okay, disposition of assets. Does that mean selling?
Well, no, that's just stating who you want to benefit from your estate. So you want to specify if you have any specific gifts. So, for instance, if you want to give your property to someone in particular, you want to name them and specify that. Some people dispose of their shares individually in their will. So those type of things you would list in your will. Who you want to be your guardian, the guardians for any minor children or disabled children that you may have provided for in your will. And also, outside of making those specific gifts, there's a term called residuary estate, which means all of the assets that you have not specifically mentioned in your will. So, for instance, say in your will you say, I leave my property to so-and-so. That's fine. And then you say, I leave my shares in Belco to someone else. That's fine. And then your residual estate would be assets such as bank accounts in your sole name, jewelry, personal effects of vehicles. That will form your residual estate. And before your residual estate is transferred to your beneficiaries, any liabilities or expenses associated with your estate will be paid first, and then the remainder will be distributed to the beneficiaries.
Now, there is a term intestate. What does it mean, and when does it come into effect?
Intestate is where someone has died without making a will. And in that case, the Succession Act will specify who is entitled to receive your estate. So, for instance, it breaks it down into if you are married but don't have any children and so forth, then everything will go to your spouse.
So if someone dies without a will and there are no children, the law automatically will transfer everything to the spouse.
Right, if it's just the spouse, so you have no siblings, no parents living, and it's just your spouse, then everything would be to your spouse.
Okay, let's go through this. Someone dies and they have spouse and children.
Then they would each, your spouse would receive your personal chattels. So for
chattels, now you brought in a new term.
Yes, personal chattels, meaning your personal belongings, furniture, things of the household would pass to your spouse. And then the remainder of your estate would be divided either 50-50 to your spouse and your children. So in a situation where you only have a spouse, everything will go to your spouse. If you have a spouse and children, then your spouse will get your personal chattels. So for instance, your furniture, the household items, your furniture, personal belongings, that will pass to your spouse. And 50% of your estate, or $100,000, whichever is greater, would be given to your spouse, with the remainder to your children.
Okay. Now, how often should one review their will?
You should review a will definitely in situations where you have disposed of assets during your lifetime or acquired assets. And outside of that, I would say generally every 2 years, you should, consider it outside of those situations where you might have disposed of them or acquired them.
Now, I understand that in certain circumstances, claims can be made against someone's estate. Give us some examples. What are some instances in which claims can be made against the estate?
Okay, say for instance someone has, they're married and their spouse is dependent on the deceased spouse. They have always provided for the household, but for whatever reason the spouse did not make any provisions for that spouse, the surviving spouse in their will, then that spouse can make a claim that they have not been able to benefit or not left anything in the person's estate.
But if in the will the spouse does not leave anything to the other one, if that is the will and that's a legal will, we did it at your firm, can claims be made against that and actually the claims won?
Well, it all depends if the surviving spouse was completely dependent on the deceased spouse. Because you would expect that your spouse would leave something to their surviving spouse if they've earned everything and were, as I mentioned, they're totally dependent on that now deceased spouse. They can make a claim to have some type of gift made to them. Oh,
okay, very interesting. Now, stamp duty, when does this come into play in terms of a will and property?
Okay, stamp duty is assessed after all of the assets and liabilities have been accounted for. The Stamp Duties Act sets out the rates in which stamp duty is paid.
Caljonah, just so that we have a good understanding, what are the stamp duty rates? Because you indicated that it's a graduating amount.
Right. So for the first $100,000 of your estate, after your expenses have been accounted for, the deductions have been made, the first 100,000 is nil. The next 100,000 is 5%. The next 800,000 is 10%. The next million is 15%, and anything over 2 million is 20%. But there are ways in which you can lower the
That's what we want to hear about.
So, for instance, there are exemptions from stamp duty. So anything that passes to your spouse will be exempt from stamp duty.
Okay.
Things passing to charities would be exempt. Assets that are not in Bermuda-denominated currency.
Things passing to children?
No.
Oh.
No.
Yeah. But let me ask you this. Since property passed to children is entitled to stamp duty, suppose you have your child on the deed, and you know you pass.
Well, if it depends on how that child is on the deeds. If you're joint tenants, then the survivor would take the property. But if it's in tenants in common, then it doesn't pass automatically.
Joint tenants, what is that?
Joint tenants is where you earn the asset jointly, and on whoever the survivor is of that asset would be the sole owner of the property. And
you say that one, is there stamp duty on that one or no?
Well, tenants in common always triggers the need to apply for probate.
Okay. Whereas
joint tenancy, it depends on what other assets you have that would trigger the need if probate is necessary.
We're almost out of time. One last term, trust, and you have about 30 seconds. What is a trust?
A trust is a legal relationship where a settler, so the person who's setting the funds into the trust, is putting this asset into the trust and having trustees administer the trust on behalf of or for the benefit of the beneficiaries who are named within the trust. So they have the trustees have the discretion, depending on how the trust is set up, to make distributions to the beneficiaries on a as need basis.
Are there stamp duties when you have a trust?
There's stamp duty on the putting the assets into the trust if they are denominated in Bermuda currency.
Okay. We have been talking with Caljonah Smith, an attorney with one of the local firms. We've been talking about wills, and one of the things that she advised us is that about every 2 years one should review their wills. And if you're single and make a will and you get married, the will that you had when you were single is now void. So again, we thank Caljonah for being with us, and we will see you on Issues next time.
Thank you.